Fundamental rights. Article 16 and affirmative action. Article 16. Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or indiscriminated against in respect or any employment or office under the state. Descent means ancestry. Nothing in this article shall prevent Parliament from making any law prescribing in regarding to the class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, and requirement as to residence within the state or union territory prior to such employment or appointment. Requirement as to residence means domicile qualification. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. The article states that there shall be equality of opportunity for all citizens relating to public employment. Does the term employment refer to process of initial recruitment only or also the whole tenure of employment? The Apex Court has remarked that the term employment not only refers to the initial employment but also whatever happens most employment concerning the job. The second clause mentions certain categories under which discrimination is not allowed. But if there is a requirement of local residence, the state government cannot impose that. Despite many chief ministers claiming the state government would impose such a thing can only be carried out by the parliament and only through law for that matter. An interesting fact is that the USA was the first country to provide a domicile quota in public employment. There was a Public Employment Act enacted in 1957 which authorized domicile quota for certain categories of posts in the state of Andhra Pradesh and the erstwhile union territories of Himachal Pradesh, Manipur and Tripura. But this act expired in 1974. Before the expiry of this act, through the 32nd Constitutional Amendment Act, Article 371D was added authorizing domicile qualification for Andhra Pradesh and now Telangana. For other states, Parliament still has to enact a law to provide for domicile quota like the previously enacted 1957 Act. The fourth clause talks about the provision of reservation to backward classes who have not been adequately represented in the services. Reservation quota debates. The term affirmative action is more refined term for reservation initially used in public by former US President John F. Kennedy in 1961 in relation to equal opportunities between people of color and the whites. Affirmative action is thus followed even in the USA. Educational institutes like IITs, IIMs, and other governmental institutions have a preferred position in our society. Similarly, this is the case in jobs like IAS, IPS, and similar nature of jobs. Thus, affirmative action is a set of anti-discriminatory measures that are provided to provide access to preferred position in society to those groups who would otherwise be excluded or may go unrepresented. These preferred or elite positions were monopolized by upper section of the society based on their gender, caste, class, etc. By providing affirmative action, the state is trying to alter the social composition of elite position. Without these affirmative action measures, the representation of backward classes in these preferred position would go unrepresented or excluded. To uplift the status of backward classes, two approaches were proposed. One was the Gandhian approach or the spiritual approach. Ashwini Deshpande in her book on affirmative action in India uses the term evangelical approach. This approach basically revolved around the moral regeneration of upper caste of a Hindu society through philanthropic uplift of the backward section. The second approach was advocated by Ambedkar, namely the objective approach that was secular in nature and not spiritual as invoked by Mahatma Gandhi. Ambedkar rejected the notion that there is going to be a change of heart of the upper section regarding the Dalit. He said we cannot wait for many years of the moral regeneration to take place, and thus we need objective measures like certain provisions in the constitution itself for the upliftment, like the prevalent provision for SCs and STs in the constitution itself. The first person in India to provide such quota was King Shahu IV, the ruler of princely state of Kolhapur in 1902, who carried out the first organized step in the upliftment of Dalits. The 1931 census carried out by Census Commissioner J.H. Hutton was the first caste census ever done in India. There was a similar exercise done regarding the SECC, but it was an exercise carried out separate from the census and its results have not been revealed yet. On the recommendation of J.H. Hutton, the first list of scheduled caste was published. He used many criteria to classify these castes, but the primary criteria were namely the temple entry restriction and pollution by touch or proximity. The debate was revolved around that under which religion should the SCs be categorized. Since the discrimination was based on Hindu system, a nature A natural inclination would be to classify all as Hindus, but many of the SCs had converted to other religions too. So the categorization that was initially limited to Hinduism was soon extended to Buddhism and Sikhism too. But the categorization of STs and OBCs is religion neutral and can be categorized from any religion. But many of the SCs also converted to Islam and Christianity and did not get the benefit of the affirmative action policies due to their non-inclusion in the SCs list. Thus, many commentators have claimed that such a policy is biased toward Indic religions. Thus, a petition challenging this anomaly is pending in the Supreme Court. In 2015, an interesting judgment was delivered by the Apex Court in the KP Manu judgment. The court said that the benefits arising out of the affirmative action for the SCs would not be applicable for members professing Islam and Christianity. But if the members converted back to either Hinduism, Buddhism, or Sikhism, they can avail themselves of the affirmative action benefits. Pratap Bhanu Mehta, a commentator, remarked that the court is extending affirmative action's benefit not on the basis of deprivation status of the community, but their conversion status. Secondly, the court also had said that the community needs to accept back the conversion. Mehta remarked that the Constitution provides freedom of religion to each individual citizen. Then how can the acceptance of community be deemed a valid criterion for the acceptance or non-acceptance of faith by a citizen, thus creating an entity similar to Khap Panchayat, and was also promoting agendas like Garvapsi. The problem also arose with regard to communities like OBCs and their status with respect to affirmative action. In the original constitution, the affirmative action benefits were availed only by the SCs and STs, but later the OBCs were added to it. In 1979, the government appointed a Mandal Commission basically tasked with the responsibility to come up with a formula or prescription as to what kind of affirmative actions benefits can be OBCs. The commission came with the figure that 52% of the population of India belonged to OBC, a figure that they derived by extrapolating the 1931 census. The commission recommended a reservation of 27% quota for the OBC community in jobs and education seats pertaining to central government. This recommendation was partially implemented by the VP Singh government in 1990, i.e., they implemented the quota only in central government jobs and not in educational institutes. In 2006, the same quota was extended to educational institutions. Identification of SCs. The central government prepares the list of scheduled castes in consultation with the state government of every state and compiles them to create a single central list of SCs. In Article 341, the provisions say only the central government has the power. Thus, the president, in consultation with the state government via the governor, notifies the list of SCs through a public notification. Any subsequent modification to the list can be carried out not only through the parliament, through a law. Thus, post the SC constitutional order in 1950 that specified the list of SCs, any further modification to the list is carried out by the parliament. This power of parliament is mentioned in the second clause of Article 341. It also further states that the modification of the list cannot be carried out through any subsequent notification, thus disallowing the executive from carrying out the action and vesting the power in parliament. Identification of STs. The procedure followed here is similar to the provision followed for the inclusion and further modification that is carried out for the SCs as discussed previously. Identification of OBCs and the role of NCBC. Until the 102 Amendment Act, for a very long time, both the center and states identified OBCs in their respective central and state OBC lists. Similarly, the state also had a state backward classes commission to aid the states in this matter. In 1993, the central government set up National Commission for Backward Classes to aid the center in matter related to the union list under the NCBC Act 1993. The composition of NCBC included the following members, namely: chairperson who is or has been a Supreme Court or High Court judge, a social scientist, 2 persons with special knowledge concerning OBCs, a member cum secretary who would be government nominee. It would entertain means take into consideration, and dispose of requests. Dispose of means give request, cast or give requests concerning inclusion into the central list, and hence the NCBC would advise the central government regarding this. This law also provided that every 10 years the central government would conduct a review of central OBC list with a view to exclude those castes that have ceased to be backward now and include those that have been freshly identified as backward, for which the central government has to consult NCBC. The law also says that the advice tendered by NCBC would be orderly binding on the government. Any deviation from the advice tendered would invite an explanation. Article 338B and NCBC. A change came out through the 102 Constitutional Amendment Act 2018, through which NCBC was given constitutional status under Article 338B. Earlier, NCBC could not entertain complaints regarding the deprivation of rights of already identified OBCs like NCSC and NCST. This anomaly was sought to be removed through this Amendment Act. The Act has been framed on similar lines as that of NCSC Article 338 and NCST Article 338A. Additionally, NCSC has also been given powers to look after the interest of the Anglo-Indian communities. The Act also added Article 342A, giving the Commission similar powers concerning the identification of OBCs that the NCSC and NCST enjoy through Article 341 and Article 342 respectively. 105th Constitutional Amendment Act 2021. In the Maratha Quota judgment, the Apex Court remarked that by the virtue of 102nd Amendment, that the power to identify OBCs has been vested in the Union government only, as in the case of SCs and STs. Thus, the 105th Amendment Act was passed in 2021 to correct this anomaly that had crept in. Crept means here shows submission, in which was not the intent of the Act. Article 342A and 338B were amended in this Act. In Article 342A, third clause was added saying that every state can prepare their own list, as the situation was before. Further, a clarification that the 102nd Act meant only powers concerning the central OBC list was added to. A further amendment was made in Article 338B, where the existing provision was that each state government had to consult with NCBC before any modification to the state list. This was sought to be amended in the 105th Amendment Act. Thus, a provision was added that the provision shall not restrict the state government power to identify their own state OBC list under Article 342A, Clause 3. Why do we need reservation policy? This debate was generated more heat, less light. This debate is necessary. Points in favor of affirmative action. Historical injustice. The affirmative action policy benefits the accrue. Accrue means pass to the backward classes in compensation for millenniums of historical injustice like untouchability, economic deprivation. It is followed in the USA too due to history of racial justice. It is also followed in Australia for the injustice meted out to Aboriginal tribes. Division of laborers, not labor. The laborers means who work with their hand. The work is assigned is based on the accident of birth and not merit. In the modern economy, the link between the person's caste and employment is considerably broken. But this link is considerably broken is true for upper caste. The lower caste still face the historical linkage of occupation based on their caste, with the Dalits, in particular, facing the burn in manual scavenging, coinciding of classes and caste distinction. A person of lower class usually means a person is poverty stricken. Similarly, a person from lower caste faces social isolation. These two identities coincide considerably in the weaker section of the lower caste facing both poverty and social isolation. This is more likely to happen with Dalits, where landlessness is more. Landlessness means quality of being without land. Untouchability. Untouchability in its original form as practiced in colonial India may not exist, but it doesn't imply that untouchability has been eradicated. Its form has changed. Examples include keeping separate utensils for domestic help, asking them to remove their footwear outside the kitchen, difficulties in renting faced by Dalits, honor killing for pratiloma, marriage, caste demands in newspaper, matrimonial for urban areas too. Thus, the manifestation of untouchability in its earlier physical form may not exist, but its form has changed and still exists in its new form in society. Labor market dualism. Ashwini Deshpande in her book Affirmative Action in India talks about labor market dualism. It says that with all things being equal, labor market outcomes should be equal to, but this is not prevalent according to her. An interesting study conducted by Thorett and Atwell in 2007, where they conducted a social experiment where three applications with the identification of Hindu, non-Dalit, Hindu, Dalit, and a Muslim with same qualification accept the identity markers. Even when all the things were equal, the market outcomes were different, bridging inequality. Thus, it is through these gentle pushes and nudges means slight push, that the unequals become somewhat more equal. The normal process of development doesn't bridge the gap between the dominant and weaker groups as desired. Thus, the gap between equality in law and equality in fact is bridged by affirmative action. Benefit society. The policy of affirmative action should not be seen as catering to the interest of an individual availing the benefit alone. It also has to be seen benefiting the interest of entire society by promoting the interest of the weakest in the society. It thus allows the full utilization of the talent pool in society. Arguments against reservation policy and debunking associated myths. Perpetuates injustice to tackle injustice. Perpetuates means cause to continue, injustice to tackle injustice. It is argued that the affirmative action was promised to rectify the historical injustice against the weaker section, but this is akin to rectifying injustice by doing injustice. Akin means similar in quality or character to rectifying injustice by doing injustice. But on deeper examination, this argument is specious. Specious means that seems to be good, but not so, because the notion that a person from a weaker section can compete equally with a person from the dominant sections is not valid, generates caste distinction and generates hostility. The argument is that such a policy increases caste consciousness and distinctions and further increases the hostility among the various castes. This argument too is flawed because the existing system of social stratification already has created such caste distinctions and hostility, and affirmative policy has been created to counter and rectify such distinctions. This is corrective justice. Compromises merit. Merit is not something that an individual is born with. Merit is inculcated in person due to his own efforts and also due to her surrounding. The education he gets, the familial support, the lack or presence of discrimination, the quality of schooling and post-schooling support etc. Thus, merit is not inherent but assisted. This inculcation of merit is deficient or absent in weaker sections due to environmental factors and discrimination. Compromises merit and hence productivity. A study done by Deshpande and Westhoff in 2012 in railways concerning the period from 1980 to 2002, they measured that the productivity of officials from the reserved category versus the officials from the open category. They found out that there was an inverse relationship between the presence of reserved officials and the presence of accidents in the railway zones. They found that the Dalit officers were far more efficient in managing Group D employees who had an overrepresentation of Dalits in their group. In the US Army too, it was found that the black officers are efficient in dealing with the black soldiers than the white officers. The better performance of ST and ST officers in the railways was attributed to the greater drive in officers to prove their persistent critics wrong regarding their work productivity and competence. There are multiple studies demonstrating the same point. Cornering of benefits by creamy sections. It is also alleged that the creamy sections of the weaker section corner all the benefits of affirmative action. What is required is better targeting rather than abolition of affirmative action itself. Moreover, this issue of poor targeting is a symptom of all government schemes other than affirmative action policy only. Mismatch hypothesis. This hypothesis states that a significant number of reserved candidates are unable to cope with the rigors of the intensity of efforts required to succeed and hence drop out or poorly perform. This doesn't call for revocation of affirmative action, but for policies like extra classes, remedial classes, psychological counseling by the government. Why caste, not class? It is based on the notion that the poor Brahmin and poor Dalit face the same handicaps in the pursuit of merit. The argument cannot be further away from the truth. The poor Brahmin faces a scourge. Scourge means curse. Curse of poverty alone, while the poor Dalit has to face poverty in addition to social isolation. Moreover, affirmative action is not a poor alleviation remedy, rather a remedy for inadequate representation, and such poor section are present in each community for which government has many remedies.